Good evening. I'm glad you're with us tonight here on Life Ahead on PBS Fort Wayne. I'm the host of the show, Sandy Thomson, but our real guest is a gentleman you're going to meet in a minute. But I think most of you, if you watch us regularly, will recognize him. Bryan Nugen is with us here this evening. That means it's going to be a legal show. So if you have legal questions, this is your chance to call in and get some advice from Bryan. Now, our main topic is going to be talking about elder law and estate planning, and we're going to try to solve some of the questions that you might have, that I have, and even some, I don't want to call them myths, but misunderstandings, I think, that a lot of people have about that. Okay, let's meet Bryan Nugen again. He has been on our show many, many, many times.
Yes,
in fact,
thank
you're
you.
on our show monthly nowadays, it seems
That's
like.
right. Good to see you, Sandy.
Good to see you.
Thank you.
You've had a good winter?
A great winter so far. We've had sunshine lately, which makes it a lot easier to suffer through.
It does. And it was like it was, it's been so cold lately, but with the sun shining, you don't mind it as much.
Well, we're in northeastern Indiana, so it's going to be cold, but as long as the clouds part and we have some sunshine, it's most definitely a much more enjoyable winter, for sure.
Well, according to weather records, February is really the worst month.
Is it? Okay, well, you should know. You should know. You're the weather expert.
It depends on what you call worst, but it's generally the coldest month and the snowiest month. Historically, as far as records, but of course that can change.
For me, it's the gray days in the winter that are tough. Yeah,
it is.
Without a doubt. That's the tough part.
By March, you're like, if we don't have sunshine at least an hour this week, I'm
the
gonna
days are
scream.
stretching now, though. The days are stretching out. So the sun is up earlier, the sun is going down later. You really can see a change from where it was in mid-December, for sure.
That's right.
Yep.
Okay, all right, enough about weather, and I'm sure you're discussing weather with your friends as well. Certainly this is a challenging season, but we'll get through it, and it'll be spring in no time.
That's right.
Okay, elder law and estate planning. That's basically what we're going to be talking about. Bryan, what's the difference between estate planning, an estate planning attorney, and somebody who helps you with elder law?
Sure. So I know we've talked about this before, but I always like to set the stage. So estate planning, we're planning for where my money goes at the time of my passing, who's going to be responsible for making sure my debts are paid and transferring the wealth in the manner in which I'd like to have accomplished during my lifetime. Typically, we do that through a will, through a trust, a beneficiary designation on items. Elder law does all of that, but elder law is also focusing on protecting assets during your lifetime, so asset protection and maybe securing benefits from programs like Medicaid or VA. So elder law is a little bit more robust than estate planning, and both are important and come into play for folks at different times of their lives.
Got it. Okay. All right. And what we've also talked about, Bryan, is you don't have to be elder to use an elder law attorney.
No.
A lot of young people do to get documents in place, whether it's a guardianship or naming a power of attorney, things they should have, especially if they have children.
Yeah, so when I think of elder law, I know the word elder, the first thing you think of is somebody that's 65 or older, but elder law attorneys oftentimes are working with, as you said, Sandy, guardianships or special needs trusts, supplemental needs trusts, those types of things. So for folks that may have a disability, we want to shelter assets inside of a special needs trust, supplemental needs trust, to make sure that those assets are there to take care of them throughout their life, and they're also able to access public benefits.
Got it. Okay.
Yep.
All right, now I'm going to switch to another money issue. Let's talk about taxes a little bit.
Yes, ma'am.
A lot of people are concerned, or it seems like they are, when you hear people talking about if they have to pay a lot of taxes.
Sure.
When they pass away. Maybe they're not worried about it, but maybe their power of attorney or their children or somebody might be. What's that situation? Do you? I mean, are there taxes that you'd be responsible for?
Well, it affects a very narrow part of our population.
Okay.
In Indiana, there is no inheritance tax any longer. In the surrounding states, I think Illinois is the only state that still hasn't, maybe Kentucky has an inheritance tax, meaning the state imposes a tax. But Indiana, Ohio, Michigan, there are no inheritance taxes that are imposed by the states. So that's the state, I call it inheritance tax.
Well, people did, and I remember, even growing up, hearing older people talk about well, I'm going to have to pay so much inheritance tax, you know.
Yep.
But what was it, 8 or 9 years ago that they
Could have
ruled
been
Indiana
2010,
didn't have it?
11, 12, something like that.
Okay.
They got rid of it. So if we're not going to be paying state inheritance tax, the next question is there a federal tax that needs to be paid?
Oh.
So just like in every April, right, we're starting to get prepared for our income tax season. We have a state income tax return. We have a federal income tax return. In our estates, we also could be paying federal estate tax, but it affects 0.14% of the population, so a very small portion of our population. So this, in the year 2025, you could have $13.9 million at the time of your passing and pay no federal estate tax. And if you're married, you can take your spouse's $13.9 million worth of credits. So we're almost at $28 million that a married couple
That
could
you would
pass
have before you pay taxes?
before you pay any tax. So the discussion of avoiding that inheritance tax, avoiding estate tax, it doesn't necessarily come up in a lot of meetings anymore. We may dispel, attorneys, your estate planning attorney, your elder law attorney may dispel that concern for you right when you're coming in to speak with them, so that isn't a large part of our planning anymore because it affects such a small part of the population.
0.14%.
0.14%. Yep, how about that?
Not many people.
Not many people.
And probably not a lot of people that with the combined resources have what,
Together.
28?
Yep. Just shy of 28 million.
28
Yeah.
million.
Yeah, that's a large chunk of
If you do, call me. I'd love to meet you, you know.
Fair
okay.
enough.
Okay, all right. Then taxes, that's one thing that we want to talk about. What about gifting? You hear a lot of people, I know in the past especially, talked about gifting as a way to decrease their assets.
Sure.
To pay less when they pass away.
Mm-hmm.
Is that still something that's happening? Gifting to their children, grandchildren, whatever?
Well, right now, our gift tax exemption this year is $19,000. So you can give $19,000 a year away and not have any gift tax consequence as the person that's giving it. The person that gives it actually pays the tax. So there was a time in estate planning we would look at some type of a gifting program over time to reduce the size of the estate. But that gifting now isn't nearly as common as it once was because that federal estate tax level is so, those credits are so high that I don't see a lot of gifting going on just for the sake of trying to reduce
that extra.
To reduce one's estate. I'm not seeing that as frequently. I will add something to that, though, because we're talking about elder law and protecting assets during our lifetime and securing benefits. One should be aware that that $19,000 gift tax exemption is appropriate for the IRS when we're looking to, we can pass money and not have a tax consequence. But if we're one that's looking to secure Medicaid at some point, Medicaid permits you to gift only $1,200 per year in total. So federal gift tax, $19,000 per person. Medicaid, if you're looking to become a Medicaid recipient at some point, a total of $1,200 per year total. Not per person, but in total. And sometimes people can get confused between, I heard, I heard you on PBS and I could give away $19,000, et cetera, with no gift tax. Although that's true, it could negatively impact your ability to secure Medicaid benefits if that's part of what you're looking for.
Okay, so something to keep in mind in that way. As far as Medicaid, looking at that as a possibility in the future,
sure.
Are there any other things you should be concerned with in terms of estate planning?
Well, as far as estate planning is concerned, we were mentioning before about guardianships, we were mentioning about special needs trust, supplemental needs trust. If you have someone in your life that you're thinking to give money to, and perhaps they are receiving Medicaid or they're they've been determined to be disabled, if you're transferring wealth to them at the time of your passing, that could negatively affect their ability to receive ongoing Medicaid. So you might consider having that money transferred into a special needs trust, supplemental needs trust for their benefit. So that's something for someone to consider if you're looking at Medicaid at time of passing. But typically we're considering Medicaid and securing those Medicaid benefits during your lifetime, not necessarily when you're passing. Okay. So, but if you had someone in your life that was getting those benefits and they have a threshold of funds or assets that they could have in their name, we should be aware of that when we're doing estate planning and make sure that the funds go into something like a special needs trust, supplemental needs trust for their benefit.
Got it.
Yep.
And right before that, you talked about you could only gift $1,200?
$1,200.
If you plan on or are getting Medicaid.
That's right.
If
you
period
gift
of
over
time
that,
is that?
if you gift over that, there is, they call it a penalty. Those aren't my words. So it's called a penalty by Medicaid. They'll look back and they'll say, well, how much have you given away in the past 60 months, the last 5 years?
Okay.
And so for X dollars, every X dollars that you've given away, Medicaid says, we're not going to provide benefits to you for a certain period of time. Could be a month, could be 2 months, could be 10 months, depending upon how much money was given away. So to your earlier question about giving money and planning about Medicaid at the time of your passing, it's not so much at the time of your passing, it's during your lifetime. If there may be a situation where you were looking to get those Medicaid benefits at some point, you should be very cautious with your gifting. The assumption is that if you are giving money away over that $1,200, the assumption by Medicaid is that you're giving it away to reduce your assets in order to be able to get those benefits. So we want to completely avoid having any appearance of impropriety, any appearance of trying to deplete your assets that way to secure those benefits. So folks should be aware of that.
Okay, and that then will involve that 5-year look back.
That's right.
Okay.
So we look back 5 years, how much have you given away, and then we divide the amount that you gave away by a certain divisor that changes every year. Yep.
Okay, every year, and
Every year
in all
changes.
states. Does the states set that, or does the federal government?
There is a federal level, but there's also, it's affected. It could be different in every state.
Okay.
So I couldn't answer the question for every state.
Yeah.
Yeah.
You don't have to. We don't expect that.
Thank you. I appreciate that.
You. Don't forget, you can call us here at 969-2720 for any questions you might have for Bryan tonight. Probate
Yes.
is another big issue
course.
that people look at when they're doing estate planning or when they're looking at finalizing or estate planning culminating.
Sure.
That was a long way to say, let's talk about probate.
Yeah.
First of all, explain what it is, and then we'll talk about how it might affect you.
Okay. So probate is the process when you pass, at the time of your passing, the individual that you've appointed, or if you haven't appointed someone, the court appoints to serve on behalf of the estate of the one that has passed. Typically, if we have a will, we're going to file that will with the court, open a probate matter, appoint someone called a personal representative, depending upon if we have a will, we don't have a will, the terms of the will, etc. We may have to ask the court's permission to do certain things. We may not have to ask the court's permission to do certain things, depending upon the type of estate that we have, if it's supervised or unsupervised. And so there's an advertising process where we advertise in the newspaper. Probate, there is no set amount of time that it takes. You know, estates can go on for years if there's litigation, if there are difficult, complicated assets to sell or transfer. It could go on for an extended period of time. It's not hard for a probate matter to be open for 12 months, maybe a little bit longer. That's not difficult at all. So when people talk about, and you hear, I want to avoid probate, or I don't want to go through probate. Probate isn't a bad thing. It's just that it can take a little bit longer. And
To get an estate settled, because we're looking at a lot of things.
there's you know
getting the judge to make decisions.
could be getting the judge to make decisions. It could just be the process that we have to go through. But what often comes with that probate process is there's an expense, right? And that expense typically is an attorney. So is there a way for us to not incur those legal expenses by going through probate? So people are looking to avoid probate for a couple of different reasons. One is to cut down on costs in your estate so you don't have as many expenses. Two is the speed of being able to get those assets out. And three, generally, is it's public. So if I was a nosy neighbor, I could go to court, I could pull the will, I can see what you've given to whom and how those things are. You wanted those things to be handled at the time of your passing. So if we are not going through the probate process, it's private. So it's typically faster, it's private, and your expenses for the estate administration are typically much, much lower without going through probate. But estates are being administered on a regular basis. It's not a bad thing. It's just to be aware, if we go through probate, that some of those things will be in play.
And from what I understand, from what you've shared with us
Sure.
before, in settling estate things, sometimes the extra time can be getting things appraised to determine a cost of something. If say there's a family with 4 siblings and mom and dad have both passed away, and you have to decide, okay, we want to make this equal for all 4 of you.
Sure.
And in mom and dad's will, they did not break it down. They just say 1/4, 1/4, 1/4.
That could be. However, even if we were using a trust, we may still need to go through some of that process. We want to make sure if the will is saying or the trust is saying everybody's treated equally. So with a trust, we wouldn't necessarily go through probate. We want everybody to be treated equally. So if there is a tract of real estate, and that's the bulk of the estate, we may need to have that appraised so we determine what the value of that is.
Right.
But that could happen maybe a little bit faster with less expense. And that
if it's
process
done beforehand.
Done before, could
what
be
you're
done
saying?
beforehand. No, I'm saying if we're avoiding probate.
Oh, okay.
The process, we're not needing to wait for the PR, personal representative, to be appointed. We're not needing to wait through those time periods. We're not publishing in the newspaper for folks to file a claim in the estate. So we might be going a little bit more quickly. But to say that we would avoid having assets appraised or determining the value of things by avoiding probate, I don't know that that would necessarily be the case.
I have the curious question.
Of course.
Which a viewer, by the way, asked me to ask.
Yes, of course.
You.
Yeah.
When we're talking about probate and settling everything. Okay, so somebody passes away, but you have to notify the public so that if there are any people that owe them money,
That's right.
or that they owe money,
So when I'm
that.
referencing advertising in the newspaper, one of the things we need to do when we open an estate is advertise in the newspaper and tell the world this person has passed away. If you believe that they owed you money, then here's your opportunity to file a claim in that estate to be paid. But also, if we know that there are potential creditors or there are creditors of the deceased, we also have the responsibility to actively notify them and say to them, this person has passed, we've opened an estate. If you believe that you're owed money, you should be filing a claim in the estate. So that is something that's incumbent upon the personal representative. That process is typically done through the attorney. You wouldn't have to hire an attorney. So I'm not promoting that you have to hire an attorney every time you go through probate, but it is a complicated process, and it could be involved if you're not used to those rules and regulations and what you're not supposed to do. So yes, if you have an estate, you do have a duty to notify creditors, you have a duty to publish in the newspaper and make sure that folks that believe they're owed money or that may be owed money are aware that they have the opportunity to file a claim to be paid.
2 things.
Yes,
Number
ma'am.
1, how long do they have to notify you, hey, your dad owed me $300 for something? How long do they have?
Sure. Well, they have a period of 90 days within which to file a claim in the estate.
90 days from
90 days
from the passing.
From the date of publication.
Oh, okay.
Yeah.
Okay.
But there are different types of creditors as well. So Medicaid has a different time frame. There are different time frames.
I see.
But generally, you have a period of 90 days. So we advertise in the newspaper. There are 90 days from that date of publication that folks have the opportunity to file a claim in the estate. Yeah.
All right, here's my second question.
Yes, ma'am.
And the viewer one. Okay, so you say you have to put it in the newspaper.
Yeah.
Not a lot of people get the paper anymore.
Well, that's
what do we
true.
do about that? How do you notify them?
So we still have to publish in the newspaper.
I understand. You have to do it.
The state says this is how you tell the world. You have to publish in a newspaper that's in general circulation in that area. So it is true that it's not as, maybe the newspaper readers, that reading has gone down and you don't see the subscription. Unfortunately.
Yeah.
It's very sad, without a
Really?
doubt. But yes, that's the process we need to go through. We publish in the newspaper. You got it.
But how is somebody going to know if they don't?
Well, if
get the paper?
again, if we're aware of creditors, then we have the duty to notify those creditors. You couldn't avoid having, if you open an estate and you're aware of a creditor, you'd have to put them on notice. Yep.
Okay, I bring that up because the person that asked me to ask about
Sure.
it totally missed a funeral
Oh,
of a friend, actually a friend,
Aw.
because
They weren't
she
aware.
wasn't in the paper.
Yeah.
You know, social media, you can't.
Yeah.
Sometimes things
I
are
think-
in there, but it's
I do
not
think
a
we're in an
must.
interesting time because
We're in a transition of
we
some
are in a
sort.
transition of some sort.
Yeah.
That's exactly right. I agree. And at some point, it wouldn't surprise me if the legislature changed and said, we're going to advertise this in a different way. But currently, we're still in the newspaper. Yep.
Okay. Okay, there you go. Now you have that answer. Hey, Peter has a call. He says if a creditor is owed money, but the deceased had no money or properties, does the creditor still get paid?
No. If there's no
No.
money there to pay the creditor, you don't need to pay the creditor. I will.
Do you have to prove to the creditor we can't pay you?
Yeah, we would have to, if there are no funds, if the estate is insolvent, the estate is insolvent. So we would let
Okay.
the creditor know the estate is insolvent and the claim wouldn't be paid. Now that creditor could say, oh, I don't believe you, I'm going to ask for a hearing before the court and I want you to show me an accounting and demonstrate that the estate in fact is insolvent. But no, if there's no money there, they aren't paid. I will say though, Peter, I want to follow up on that. Sometimes people have the concern that if I'm serving as the personal representative, if somebody's appointed me to serve in that position, that I will be responsible for paying my mom's credit card debt or, gosh, utility bills went unpaid or whatever it may be. And I will let you know that if you're serving in that capacity, you don't personally have a responsibility to pay the debts of the deceased party. So sometimes I'll hear that, but no, you don't.
Well, and I wouldn't be surprised if sometimes creditors expect that power of attorney to pay out of their own pocket.
So remember, power of attorney is during your lifetime,
Oh, that's
not
right.
personal
That's right.
representative.
Yeah,
Yes.
personal
But, yeah, they
representative.
could. And that is a question that I think estate planning and elder law attorneys receive from clients on a regular basis, which is,
Okay.
if I'm appointing them, do they have to pay these debts? Or somebody asks, if I'm appointed, am I going to be liable for those debts, those expenses? No, you're
Okay.
not personally.
Okay, all right, that's good to know. Okay, all right, now we're getting close to the end of our show, but I want you to have the opportunity to tell us what other questions you get in settling estates from clients that you've had through the years. What are common
From settling
common
estates,
issues?
I think the most common questions are length of time. How long is this going to take before the money can be distributed? I like to see personal representatives trying to get the money out to the heirs as quickly as possible, the beneficiaries as quickly as possible. People have a tendency to get a little nervous. Why is it taking so long? So I think the question is, how long does it take for the estate to go through process? How long is it going to be before I can receive my money? Those are some questions that I hear regularly from folks that are inheriting funds from a deceased loved one. Yeah.
Is it true that it also might be dependent upon when you pass away, period of the year, because of taxes? Say you have to,
Well, so
the
if
PR has to do the taxes for that
Well, that's
person.
true. So if the deceased had income tax, if they earned enough money in order to pay, file an income tax return, then we may have we may need to file an income tax return for the deceased. That is true. And in some estates, not always, but some estates, depending upon how much the estate earned while it was opened, or if there was real estate that was being transferred as part of that estate administration process, we may have an estate tax return that needs to be filed as well.
Oh, okay, all right. And then if there are things, which I know you've shared before, if there are things that you're selling, the farm, the lake cottage, the house, whatever, that may factor in too, because if it takes longer to get those things sold.
Yeah, no doubt about it. But to your point about tax returns, yes, if I'm selling real estate, that estate's going to have a tax return that needs to be filed, for sure.
Okay, okay. What else? Anything else that people come to you all the time and say, hey,
Yeah,
help?
I think that you've mentioned a couple of times power of attorney, and I've said this before. Everyone should have in place durable power of attorney, healthcare rep designation. And if nothing else, a basic last will and testament. But most, without a doubt, the power of attorney is essential to have in place, that healthcare rep designation where you're allowing someone to make healthcare decisions for you if you're unable to.
Yeah.
Without those in place, we can be forced to, it's not, I shouldn't say forced, we may need to use a guardianship. There's nothing wrong with guardianships, but we can avoid having the court involvement in monitoring assets of the person during their lifetime if you take the initiative to appoint someone to serve as your attorney in fact to that power of attorney, as your healthcare representative to that healthcare representative designation. So I would encourage all of our listeners to have those basic documents in place. It's very important. Sometimes people will say, well, I don't have enough money or I don't have enough assets. Why would I do that? Actually, it's very important for those things to be in place regardless of your wealth.
Okay.
Yep.
All right. Well, that includes all of you then.
It does.
Again,
Yep.
we appreciate so much Bryan Nugen being with us here. Thank you for
Thank
coming.
you, Sandy. I appreciate it.
And you'll see Bryan again next month here on Life Ahead. Meanwhile, have a great night and a great weekend.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.